Hi guys, good afternoon. Making sure I'm audible and this is the right room.
Yeah, this is the right room. So
Okay, thanks, Dipesh.
Hello. How's everyone?
Very well. How are you?
Good, good. Thanks.
All right. Did we get the skeleton arguments for this round?
Oh yeah, sure. It's been circulated earlier. It's
Okay.
Middlesex University, Dubai 1 versus Hamad bin Khalifa University. Is that correct?
Yeah. Okay. Yeah.
Mhm.
Yeah.
And has that been decided who is going to be chairman of the tribunal, or has it not? Should we maybe choose now?
Yeah. I think I like the mug Amir has, so let's make him. You're on a mute, by the way. We cannot hear you, Amir. Cannot hear you.
am I audible now?
Yeah.
Yes.
Yeah. Well, flip a coin, as they say in England. You guys go ahead. I'm going to rule myself out.
Well,
How
I
about
thought the
you?
Yoda Cup was
This
cool.
is
Yeah.
just to volunteer. This is my first time as a judge for this particular event. I'm doing a favor for somebody, so I really don't know the procedure, what happens. I've never done it in the past. I've read the documents, but other than that, uh, I'm at your service.
Well, it's the same for me, to be frank. And unless either of you volunteers, then well, I
Well,
could
I
do it.
can.
I've never
Yeah.
done it for this
Who's done this before?
I've done it. Yeah.
particular
Yeah.
competition. I don't think anyone has.
Okay.
Yeah, so I mean, I've judged the previous round. I don't know if anybody did on this panels, but yeah, quarterfinals first time. But I think the rules pretty much apply the same. Of course, I've been to other competitions. I'm happy to volunteer. So,
Okay. Thank you.
but again, I guess it's I think we can all do the same job collectively as well. But yeah, for the sake of record, I'm happy
No
to be
problem.
one. Yeah.
As far as the marking goes, where I've got a sheet in front of me, I take it we're marking as we go along. And do we collate the marking for you, Chair Bijan, for in the judges' room after we just collaborate, talk about it, and only one of us will email the collective scores? I take it. Is that correct?
Yeah, that's what. So I think what we'll do is we'll take down our individual scores. We'll quickly calibrate it after the arguments are over, and one of us can send it. We'll copy the other two. So
Thank you very much.
yeah.
I like that. Fire and forget.
Right.
So, well,
Yeah.
it's all on you, Bijan.
I wasn't sure what I was signing up for, but yeah, happy to do that.
With great
All
power
right.
comes great responsibility. So it's
Responsibility.
you.
Yeah. Already feeling the pain on my shoulders now. All right. Okay. So I guess so. With that said, we still have, I guess, about 5 minutes. I'm if the claimants and respondents have joined, please kind of identify so that we know you guys are here, and there's no harm in starting a little early if everybody who is needed is here.
Is Hamad bin Khalifa University present? The participants of Hamad bin Khalifa University?
Yes, the senior defendant are joining in now. Yes.
Okay.
Hello, can everyone hear me?
Mhm.
Yes. So could you please, so the four of you, I'm guessing from two from each side, is that correct? Because I also see there are more people in the room. So if just everyone can just identify who they are and which side they are, and if somebody's from DIFC or Webnyay, then could you please just say that as well so that we know who is who?
So I'll just tell you about myself. So I'm from Webnyay tech team.
Right. Thanks, Dipesh.
I am from Hamad bin Khalifa, junior defendant.
Good afternoon. My name is Karim. I'm also from Hamad bin Khalifa, and I'm senior defendant.
Good afternoon. I'm from Middlesex University, Dubai 1. I'm Ryan. I'm the senior claimant.
Good afternoon. I'm Sarah. I'm from Middlesex, and I'll be acting as junior claimant.
Right. Thanks, sir. I see Christy and Shreka. Like, could you please identify?
Good afternoon. I'm also from Middlesex University, Dubai. I won't be speaking today, but I'm part of the team.
Okay.
Hello, I'm also from Middlesex University. I won't be participating today, but I'll be in the meeting.
All right. Thanks for the introductions. Just so that you know, Anton, Amir, and myself, we are the judges for this round. As required, I would request claimants to identify the division of time and also the order in which you are going about, and then followed by that, defendants could please do the same.
I'm the senior claimant, and I will be speaking for 18 minutes. And I'll be addressing the first ground of the proceedings. My junior counsel is Sarah. She will be speaking for 18 minutes, same, and she'll be addressing the second ground of the proceedings.
Right, so that will leave you guys 6 minutes each for rebuttals. Is that what you have in mind?
Yes, Your Honor. Yes.
All right. Right, counsel for the defendants, please.
Yes, Your Honor, I'm the senior counsel, and both my co-counsel and I will speak for 20 minutes each, and we will reserve a total of 5 minutes for rebuttal.
Okay, all right, thank you. With that, with my fellow judges, if you guys permit me, we'll allow the claimant to open up the case.
Yep.
Right, claimants, please proceed.
Thank you, Your Honor. Good afternoon. May it please the court. I'm Ryan, the senior counsel for the claimant, along with my co-counsel Sarah Jamshad. The counsel is appearing before the Honorable Court in the matter of Ms. Artemis Astrothea and Solar Dream Incorporation on behalf of the claimant under the DIFC Court of Space. Would Your Honors benefit from the key facts of the case?
Yes, please.
The facts of the case here are: the claimant, a famous YouTuber known for her Astro Yoga channel, bought a $10 million worth ticket for the defendant's Star Alliance spaceflight retreat. She hoped that the retreat's promise of enhancing life force would cure her chronic headache. However, she failed to disclose this headache of hers during the medical evaluation and checkups out of the fear of being barred from the retreat. Subsequently, on the day of the flight, she was suffering from a headache but failed to disclose it due to the significant investment she had made. Moreover, on the day of the launch, despite a delay in receiving the PCR results, which were initiated in light of the COVID variant outbreak, the flight proceeded with the lateral flow test results because of the meteorological conditions leading to the launch window to close. However, shortly after the launch, it was discovered that the claimant tested positive for COVID-19, leading to all passengers and crew members contracting the virus and an early return of the flight to Earth. Your Honor, today, we seek restitution for the claimant due to the defendant's negligence and subsequent breach of contract, entitling the claimant to $15 million for the losses she had suffered and the gains she was deprived of as a result of the defendant's actions. And as mentioned earlier, I will be dealing with the first ground of the proceedings and speak for 18 minutes, and my co-counsel will be dealing with the second ground and speak for 18 minutes, respectfully reserving 6 minutes for the rebuttals. Today, I will be covering three main issues. Firstly, the defendant's failure to exercise reasonable care causing losses to the claimant. Secondly, the defendant's breach of contract in failing to deliver the services the claimant had paid for. And thirdly, the claim for loss of earnings resulting from the claimant's inability to film the highly anticipated videos the claimant had advertised. May I begin with my first submission, Your Honor?
Yes.
Thank you, Your Honor. My first submission concerns the defendant's failure to ensure the safety and well-being of its passengers, including the claimant, by not following proper medical evaluation procedures and thereby being negligent. Under Article 17 of the DIFC Laws of Obligations, there are three conditions to be satisfied in order to establish a negligence liability. The first condition, according to Article 17, Sub-Article 1A of the DIFC Laws of Obligation, is that the defendant must owe a duty of care to the claimant. This duty of care is further illustrated in Article 18 of the DIFC Laws of Obligations, which establishes that a duty of care exists where it is foreseeable, where there is sufficiently proximate relationship between the parties, and it is fair and just to impose such a duty on the defendant. Here, the Council contends that there exists a duty of care between the defendant Solar Dream Incorporation and the claimant Artemis Astrothea. As parties to a contract, it is reasonably foreseeable that a sufficiently proximate relationship exists between them, and given the considerable money involved in the contract, it is fair and just to impose such a duty on the defendant. Additionally, it can be seen that this provision of the DIFC Laws of Obligation is based on Article 5.1.4, Sub-Article 1 of the Unidroit Principles of International Commercial Contracts 2016. This article provides that to the extent an obligation of the party involves a duty to achieve a specific result, that party is bound to achieve that result. The subsequent commentary, which can be found on which can be found on page, I apologize for the delay, Your Honor, it's technical, which can be found on page 18 on the claimant's bundle, clarifies that the nature of the duty of care in this case is that which raises the duty of the defendant to achieve the specific result of providing the agreed service, including the meditation and yoga sessions within the agreed time to the claimant. This highlights the fact that there exists a high standard of duty owed by the defendant to the claimant. Subsequently,
Counsel, you are arguing that the defendant had owed you a duty of care, and this argument is in reference to proper medical evaluation ought to have been done by that. Right? That's your argument. Now, you were suffering from headaches for a considerable amount of time, and in last week, the second week of quarantine in Dream House, that had gone worse, right? The law of contract, DFC law of contract says the party, aggrieved party, has also duty to mitigate the harm that would have caused to them. Applying that principle to your case, you never disclosed your headaches to the defendant, but now you're expecting them to owe you duty of care. That is not fitting into the argument well. So how do you see that?
Your Honor, I believe that the submissions about the non-disclosure of the claimant will be discussed by my junior counsel. However, I would like to say that the specific result from this contract the defendant is bound to achieve is the fact that they are supposed to provide a once-in-a-lifetime opportunity to the claimant to engage in a solar-powered meditation and yoga session in space to develop this life force, as said in their advertisement.
Correct. That opportunity is a business proposition, right? How do you balance that with the fact that you yourself wanted, as a claimant, wanted to avail that opportunity, but were not mindful enough to disclose a medical condition, but now expect the defendant to complete the medical evaluation. They both go hand in hand. While you expect them to exercise due care, you have not shown due care, right? So, simple legal question on the point of law is, how do you satisfy an argument that Article 117 of the DIFC contract law is not applicable here?
Your Honor, can you rephrase the question again, please?
So, okay, are you aware of Article 117 of DIFC contract law? You may refer to it if you have a copy in front of you.
Yes.
But question is, you had also duty to mitigate the harm that would have caused by any potential medical evaluation, right? The Article
Yes.
117 kind of mitigates your claim completely, or for most part, right? How do you, what is your counter argument to Article 117 of contract law?
Your Honor, just give me a minute.
Sure. It requires the suffering party or the aggrieved party to be taking reasonable steps, and in this case would be to disclose the medical condition, right? So that addresses the point of standard of care or duty of care expected from defendant, but it also applies in the same length to the claimant.
Yes, Your Honor, I do understand Article 117 asks the claimant to mitigate her risk. However, I believe that in the following submissions, we would differentiate the claimant's non-disclosure from the defendant's negligence, saying that the claimant's non-disclosure did not affect the defendant's negligence or breach of their duty or falling below the standard of care.
Okay, please move on. Yeah.
Thank you, Your Honor. Subsequently, the second condition, according to Article 17, Subarticle 1B of the DIFC Laws of Obligations, that says that the defendant breaches his duty of care to the claimant. Your Honors, here, the facts indicates that the defendant has breached their duty of care to the claimant in several ways. Firstly, the defendant has fallen below Article. The defendant has failed to comply with Article 6, Subarticle 1J of the UAE Regulation on Human Spaceflight 2022, which requires the spaceflight operator to provide evidence that participants are medically fit to participate before the launch. However, here, by launching the flight before receiving the PCR test results, the defendant has failed to ensure that participants were fit as required by the regulations. Secondly, the defendant failed to comply with Section 4.4.4 of the Recommended Practices for Human Spaceflight Occupant Safety 2023, which requires identifying medical conditions that could result in the flight ending early and taking reasonable steps to mitigate these risks. Despite being aware of the COVID-19 variant situation, the defendant failed to act reasonably to protect the participants, including the claimant, where the reasonable actions might be to wait until the PCR test were to return or to reschedule the flights as per clause 1.2 of the contract, and thus making sure that participants were fit for their exposure to space. Therefore, the counsel argues that this non-compliance highlights the fact that the defendants have fallen below the industrial standards, thus risking the life of the participants and the crew. Moreover, the counsel also argues that according to a comparison study between the efficiency of PCR and LFTs reported in the Dove Press, which can be found on page 19 on the claimant's bundle, shows that the PCR tests are often more reliable, especially when it comes to individuals who are not at their peak transmissible stage of their infection. Moreover, inconsistencies such as a negative LFT and a positive PCR in this case may also occur due to inadequate swab collection or testing procedures. So these inconsistencies highlight the importance of having a qualified medical personnel conduct the evaluations and make informed decisions. However, in this case, the nurse reliance solely on the LFT results without waiting for a more accurate PCR test demonstrates a lack of proper medical oversight and expertise. This can also be highlighted by the fact that the nurse was not qualified in aerospace, as required by the regulations mentioned earlier. This failure to follow appropriate protocols and ensure the safety of the participants before the spaceflight represents a breach of the defendant's duty to provide a sufficient and qualified medical team for a significant investment project as this. Therefore, the Council asked the Court to consider that the defendant's conduct here shows that medical evaluation and oversight of the space fall short of the reasonable standard expected from the defendant according to Article 21 of the DIFC Laws of Obligations, indicating a breach of their duty to ensure the safety and well-being of the participants, including the claimant.
Council, I follow your argument. However, there is also a provision to exempt or absolve a party's obligation if there is a force measure. Now, pandemic, COVID, and whichever variant of COVID was that, kind of falls under the force measure argument, right? Now, the fact that they still attempted to evaluate the PCR timeliness of PCR results is a different issue, but the fact that it was a COVID pandemic and ultimately it was because of the breakout of COVID in the flight had to return. So defendants would argue that they are fully exempted from their contractual obligations because it was a force measure. No, they could not have foreseen it. They attempted, but beyond reasonableness, they could not have. So all other arguments you made, kind of, how do they kind of counter the force measure argument?
Firstly, the Council condemns that there is no force majeure clause within the contract between the claimant and the defendant, and neither does the contract contain any clause of the force majeure nature. Moreover, the claimant's losses here clearly fall within the scope of the defendant's action because the defendants were aware of the COVID variant situation prior to the launch. Exactly from the facts, 1 month before the launch, they were aware of the fact that there was a COVID situation going on, and also it is an unprecedented one where they knew what should be done in order to mitigate these risks. This is also evident from the fact that there was a cursory test that was conducted in this light.
All right, thank you.
Moving to the third condition. Third condition, according to Article 17, Subarticle 1C of the DIFC Laws of Obligation provides that the defendant's acts or omissions in this breach of his duty should cause a loss to the claimant. According to the report by PubMed, which can be found on page 24 of the claimant's bundle, shows that there is a possibility these COVID viruses might be dormant and an LFT might not be able to detect these dormant viruses. Instead, often requires PCRs. In such a situation, it suggests that by exposing such a dormant virus carrier to space might lead to activating these viruses, often putting the claimant at risk. Here, the Council argues that the claimant's initial headache could be attributed to a chronic headache, as that was the only symptom seen in the claimant apart from the fatigue resulting from the traveling. However, by exposing her COVID viruses to space, as identified by the PCR, the defendant has led the viruses to activate, putting the claimant at risk again. Here, upon reaching yoga mat, it can be seen that her condition has worsened, where she was too unwell to undertake any meditation or yoga even on her own, or to film the videos she had advertised. Moreover, had the defendant timely identified that the claimant was a COVID virus carrier while she was on Earth, she would have received proper medical attention and rescheduled the flights as per clause 4.4 of the contract, which would have prevented the loss of opportunity to record the space videos, Your Honor. Thus, although not the sole cause, the defendant has contributed to the losses of the claimant, thereby establishing a link between the breach and the loss caused. Hence, the defendant's failure to follow proper medical evaluation procedures and to take appropriate measures to prevent the spread of the virus resulted in premature return of the spaceflight. Therefore, the Council condemns that the defendant has been negligent under Article 17 of the DIFC Laws of Obligation by breaching its duty of care to the claimant who has relied on them and made a considerable investment. That concludes my first submission, Your Honor. May I move to my next submission?
May I ask you a question, Counsel?
Yes.
My turn now. What's your take on paragraph 4.5 that has to do with limitation of liability, say for instances of willful misconduct or gross negligence? You mentioned that negligence, but was it gross? Because it's debatable.
Yes, Your Honor, it was a gross negligence, putting the claimant at risk. However, my take on the clause 4.5 is that clause 4.5 can be considered unfair for two reasons. Firstly, the defendants were aware of the fact that what the claimant was bound to achieve from this trip. One, curing a headache, which can be seen from the facts, and second, the recording of the YouTube videos. And the defendants were also aware of the possibility that the claimant would not be able to achieve this objective of hers. Secondly, it would be unfair to exclude or limit the liability when the term in itself is unfair, as the claimant did not have real choice to disclose a headache in the medical evaluation after making the considerable payment of 5 billion.
Yeah, but again, to the best of my knowledge, gross negligence is the, let's say, it's the lack of even slight or scant care, and according to the facts of the case, the defendant, well, you could argue that the test was superficial, but they did the bare minimum, at least. Okay, so it's not the complete lack of care. It's some, to some extent there was certain procedures undertaken. So why is it gross?
It is to be considered. The court should consider this as gross negligence because it has put the claimant at risk of her. It has put the claimant at risk of safety. She had suffered. Her condition has worsened. Her physical condition has also worsened because of traveling to space without the knowledge that she was a COVID virus carrier.
Okay, and one last question. Again, I'm sorry, I might be delaying you. A question on the facts. The medical condition was not disclosed because, as I understand from your submission, that the claimant didn't believe it was important, that it would affect the flight. At the same time, if we look at the Moot problem, and in particular paragraph 8, it says that the reason not to disclose was that your client was afraid that a solar gym would not let her board the spacecraft. So if she was afraid that she wouldn't be allowed to participate, doesn't that show that she understood that this could be an issue?
Your Honor, this issue is discussed in detail by my junior counsel in her submissions.
Okay.
Just one point. Counsel, you said that claimant's intention to record YouTube videos during this mission were known to defendant. Whereas in the agreement it says that this is why the defendant was signing up the claimant. The object of the agreement as captured in the recitals is very clear that it is to experience space yoga. There is no reference to any kind of videography to be done.
Yes, Your Honor, the contract does not expressly state that they allow the recording of videos. However, from the facts, it can be inferred that there was no restrictions on recording any videos. And also the defendants were aware of the fact that she was a famous YouTuber, and thus there would be a possibility that they were reasonably aware that she might record these videos and post it on her YouTube channel.
Right, but now because she has not been able to record it, that cannot become a ground for seeking damages. That was a remote possibility that if she was on the space yoga mat, she will record it, which is not an object of the agreement. The previous discussion with the sales representative, they do not apply because the agreement has an entirety clause. So we cannot infer anything else but look at just the agreement. Right? There's a clause which says this is the only agreement, nothing before or after applies. So do you have to, because your argument appears to be that, and the claim actually is that because the video could not be recorded and hence part of the damages are for that. But recording the video was never in the agreement. It's not to be inferred. So why should there be even claim, whether in contract or even in tort?
Your Honor, I believe that this claim is brought up based on as under pure economic losses, which is resulting from the negligence. That is, as a result of the defendant's negligence, or as a result of defending fallen below the standard, this loss, the claimant has inferred this loss, or the claimant had failed to record these videos. So I believe that there is this is why she's bringing the claim. The claim is brought in the court.
Okay, well, I just want to inform that I think you're past your time. We're now at 20 minutes. So you may want to conclude your submission or continue with your co-counsel. Yeah.
I'd like to conclude my speech.
Okay.
Therefore,
Thanks.
the council respectfully urges the court to thoroughly evaluate the submissions and facts presented in this case and rule in favor of the claimant. And the claimant is seeking for a compensation of 15 million US dollars, encompassing the services the claimant had paid for as per the installment clause 2.2, that is 7.5 million US dollars, and additional 7.5 million US dollars as a part of loss of earnings resulting from the defendant's negligence and the subsequent non-performance of the contract. And that concludes my submissions, Your Honor. If you have no further questions, thank you.
Thanks. Senior counsel for the defendant, please.
Okay, can everyone hear me?
Yes.
Perfect. Your Honors, opposing counsels, good afternoon. My name is Karim Khazal. I represent the defendant, Solar Dream, and I will address the merits of the first issue regarding their liability in tort and breach of contract. My co-counsel, Shireen Ahmed, will address the second issue regarding the claimant's liability in breach of contract. And finally, my co-counsel and I will both speak for 20 minutes and will reserve a total of 5 for rebuttal. To begin, Your Honors, we do not dispute the construction of facts made by the claimant. Instead, I'd like to skip ahead and go directly to our arguments. And with that, we have 3 arguments in which I will mirror the opposing counsel's structure. First, the defendant is not liable in tort because they did everything reasonably practicable to minimize the safety risks of space travel. And alternatively, if the court finds the defendant in breach of their duty, then they are still exempt because the claimant voluntarily assumed the risks of space travel. And third, the defendant is not in breach of contract because they fulfilled their contractual obligations to minimize those safety risks. Turning to my first argument, Your Honors, the defendant cannot be held liable for the claimant's inability to participate in the spaceflight activities, as they did everything reasonably practicable to minimize the safety risks. Now, we agree with the claimant's construction of the requirements for a duty of care under Article 18 of the Law of Obligations. However, to prove that there was a breach of that duty, it must be demonstrated that they acted below the standard of care that would be reasonably expected from someone or a party in their circumstances. And this is where our view diverges. Your Honor, the defendant's only reference as to how they could have reasonably acted in the circumstances were the relevant provisions of the UAE human spaceflight activities regulations. And if we take a look at those, Article 4.2 specifies that the spaceflight operators must obtain the necessary approvals, which they have done so. Any person who wants to conduct human spaceflight shall obtain an authorization, and that was done. Articles 5 and 7 obligate the spaceflight operator to train the crew, which they have also done, and this is present in page 2, paragraph 1 of the record. Also, the defendant informed the claimant of the risks involved in accordance with the provisions under Article 6.1. And finally, the defendant conducted 2 medical evaluations on the claimant in compliance with 6.1J, which specifies that they have to provide evidence that human spaceflight participants are fit to participate therein. And here I would like to draw your attention, Your Honor, to the spaceflight operators' obligations as set out in the regulation. It is not to ensure that their participants are fit for spaceflight. It is actually only to provide evidence that they are fit for spaceflight. And the regulations create this distinction because ensuring their fitness to participate is an impossible standard that cannot always be met. We will always have exceptional cases, as is the case here, where a participant can withhold information about their health and safety and end up not being able to participate. And so, in accordance with the requirements, the lateral flow tests actually demonstrate that they are actually evidence that the participants were fit for spaceflight.
Council, the facts
Yes,
of
Your
the
Honor.
case say that there are a couple of points I want to make here on the submissions you have made, and let's start with the lateral flow test, right? Now, the facts indicate that it was the advice of the nurse who was on duty, that it was her advice, that's para 12, that it was the advice of nurse on duty that the lateral flow test was sufficient statistically to rule out any serious risk. Now, how not means the nurse definitely is qualified to do certain task, but whether or not to carry out the space mission is definitely not something that would hinge on how a nurse interprets things, especially when Solar Dream had a former chief medical officer of NASA work for them, right? But his view was not taken. Instead, the nurse said, lateral flow test is fine, go ahead, and they go ahead, right? That seems to be a pretty casual way to go about the whole safety regulations that space flight operators are supposed to uphold and adhere to. So that can, what do you have to say to that?
I have two things to say, Your Honor. First, the retired NASA Chief Medical Officer, Dr. McCoy, actually did not offer any input on the sufficiency of the lateral flow tests or not. So the defendant did not have that information to even take into account in the first place. And second, to consider whether their acts were reasonable, we have to consider everything in the circumstances. And so you were right in saying that it does not hinge on the nurse's opinion that the lateral flow test was sufficient. But when we take into account the urgency, the closing window of opportunity for the spaceflight to take off, the readiness and willingness of the participants of the flight, then we see that they had a very short amount of time to make an informed decision. And this is the best decision they could have made in the circumstances at the time, especially when we consider that all of the participants have already quarantined for 2 weeks. And so the fact that one of them ended up getting infected with COVID after, to be honest, is a bit of a coincidence.
All
Have
right.
I answered the question?
Yeah, move on. Yeah, that's right.
Thank you. Your Honors, the spaceflight agreement also sets out that that the defendant has to, the best of their ability, ensure compliance with the US FAA's recommended practices for human spaceflight occupant safety. And so this is not a direct obligation, but it only extends to a reasonable extent. And even in that sense, the defendant has complied. And so if we look at 4.4.2a, it specifies that operators should require participants to consult a qualified physician, which, as I've just mentioned, they have done so. 4.4.2d.
Was nurse a qualified physician?
The nurse was a qualified physician, and Dr. McCoy was also a qualified physician, yes. While the nurse does not have the same qualifications as Dr. McCoy, she has been operating in the private medical sector, with people in the aviation industry for a long amount of time.
Right. I
So
believe
that
the
speaks to her credibility.
qualification as a physician comes from, the regulatory authority, especially those who are licensed to practice as a doctor. So nurse may not be a physician, as far as I'm aware. But yeah, anyways, let's move on.
Absolutely, Your Honor. And so 4.4.2d gives the operator the flexibility between mandating a medical self-assessment or having it conducted by a physician on the day of the flight. So while you're right in that the nurse was not a qualified physician in the definitions of the law, but this article shows that spaceflight operators can actually mandate the participants themselves to conduct those assessments. And yet they still didn't. They still went the extra mile of outsourcing a nurse. And so given the scope and comprehensiveness of the defendant's preparation, there is no clear evidence that they fell below the standard of reasonable care. And in more ways than one, there's an analogous case that can demonstrate this. Aegis Resources v. Union Bank of India, that is claim number 004 of 2020 from the DIFC. While the facts of this case are different, a few important points can be drawn. So briefly on its background, the claimant sued the defendant in tort and breach of contract because the defendant transferred money to a cyber criminal who hacked into the claimant's email system, and they sent them an email pretending to be the claimant. And so when contemplating whether the bank's acts fell below the standard of care, the court ensured that the standard imposed is neither too permissive nor too restrictive. And so they cited the UK Quinscare standard for banking, where the judge said that banks should have a standard of care to prevent fraud and protect their customers, but that imposing this obligation to the degree where they have to probe, quote unquote, probe every customer's requests for signs of dishonesty is too restrictive. And it would be a beneficial exercise to carry over this analogy here. And so similarly, the defendant took its own reasonable measures to ensure that the claimant was fit for travel. However, the claimant knowingly failed to disclose their symptoms. And following the same rhetoric, it would have been too restrictive on the defendant to expect them to probe the claimant to see if there was a dishonesty on their part. And so, Your Honors, to conclude my first argument, the defendant took reasonable measures to minimize the safety risks. They fell within the standards of care that can be seen in the UAE human spaceflight regulations and the US recommended practices.
Can I ask one question here, Counsel?
Yes.
Could you just elaborate or give your opinion whether it would be reasonable to reschedule the launch to fully avoid rather than just mitigate the risks?
In hindsight, Your Honor, knowing that one of the participants was infected with COVID, it would be reasonable to have done so. However, they didn't have those facts at the time, and the defendant actually had a very short window of conducting a cost-benefit analysis or a utilitarian approach as to whether they should greenlight the launch or not. And in those circumstances, the participants were ready, they were excited, they had negative lateral flow tests, everyone had already quarantined, the meteorological window was closing. So given all of those factors combined, it was reasonable at the time for them to greenlight the launch.
Okay.
And so turning to my second argument, even if the court finds that the defendant was in breach of the standard of care, they should still be exempted under DIFC Law of Obligations Article 55 because the claimant voluntarily assumed the risk. Now, Article 55 presents a defense that exempts a party from their failure to meet the standard of care, if the harmed party willingly undertook that risk. In our case, we argue that there were two instances where the claimant voluntarily assumed this risk. First, when she signed the spaceflight agreement, where clauses 4.1 and through 4.6 set out the various risks involved in space travel that may result in the cancellation of the flight. And second, the claimant voluntarily assumed this risk when she knowingly failed to disclose her symptoms, even though she had ample opportunities to do so. And so allow me to elaborate. The doctrine of volenti non-fit injuria means that to a willing person, no injury is done. And so if a person willingly consents to the infliction of harm upon itself, then they are not entitled to get any remedy under the law of torts. And so we can look to a landmark English common law case, which is Hall v. Brooklands Auto Racing Club, 1932. In this case, a spectator was at a car racing event that was organized on the track, which was owned by the defendant's company. During the course of a race, a collision occurred between the cars, and the spectator was injured as one of the cars landed on them. So the spectator sued the defendant claiming compensation, and it was held by the court that the defendant gave implied consent for taking risks, and hence defining that phrase. So this precedent case is important for three reasons, Your Honors. First, there is no existing DIFC case law until as of now that sufficiently sets out the legal test for the principle of volenti non-fit injuria. So where better to look than a landmark case from the English common law courts. And second, while the fact patterns are different, this case is analogous because it sheds light on the fact that a voluntary assumption of risk can be either expressly made or implied. And in this case, the assumption was both. It was both expressly made in the contract and implied when she did not disclose. And third, as a matter of policy, it's actually in the court's interest to develop a cautious attitude towards space travel because it is still new and quite dangerous. And so knowing that there are lots of, yes.
Counsel, as far as the risk in relation to space travel are concerned and how the space flight agreement addresses it, it is the inherent dangers and even the wordings in the agreement are clear that in terms of the effect of gravity on the body and those peculiar risks that exist only with the space travel. However, in this case, none of those risks have materialized. This, what has happened in the space flight has actually is something that happens on the planet Earth in the recent times, right? So the risk addressed by the agreement are not the risk is not the risk of pandemic. The risk of pandemic is prevalent on the Earth as much as it became prevalent on the space flight, right? So what other risk did the claimant assume in the agreement? There was no other risk that they were assuming, right? The risk of the agreement only says there's a risk of rescheduling and postponement, delay and rescheduling. However, what has happened is the space flight wasn't delayed. It was pushed to leave on time and brought back because of the pandemic. So the risk of delay and rescheduling is not the case here, right? The risk was flight took off, pandemic, everybody got infected on the flight, and the flight came back without achieving its purpose. None of these risks are in the agreement, assumed expressly or implied. Do you agree with that?
To a certain extent, Your Honor. The risk that the claimant undertook in this case is actually the risk that she would not be able to participate in the space flight for whatever reason. And so to support that, clause 4.2 of the contract, actually 4.3 of the contract specifies that the passenger acknowledges the potential health risks associated with space travel. And while it sets out a bunch of potential side effects, it repeats the phrase including but not limited to. And so the health risks could span anything. And so it's merely about the fact that she could not participate in the space flight and film the series she wanted to film. This is the risk that she undertook when she signed the contract and when she decided not to disclose her sickness. And seeing that I'm short on time, I'd like to briefly move on to my third argument. So the defendant is not in breach of contract because they complied with the relevant provisions under the UAE Human Spaceflight Activities Regulations and the US FAA's recommended practices for human spaceflight occupant safety. And so Article 77 of the DIFC contract law defines non-performance as a failure to perform a contractual obligation. And so the relevant provisions from the spaceflight agreement about safety protocols are 7.1 and 7.2. And both of these clauses afford the defendant a degree of discretion in that they don't necessarily have to make sure that every participant is fit for flight. They just have to take every reasonable measure that they can, and which they have done. And so with that, I'd like to conclude my pleading, and I'm in your hands, Your Honors, if you have any more questions for me.
Thank you. I have one question. The counterparty is the consumer. That's what the contract says. And normally, a consumer is a weaker party. What your opponents are now saying that as a consumer, they disclosed whatever they reasonably believed was important. So, you know, I mean, was there a larger, so to say, duty of care on the part of the service provider compared to that weaker party of yours? What's your position on this point?
I will just add a supplementary question to what my fellow judge asked. You are the expert in the space travel, not the customer, correct? So you ought to have known the risk of proceeding with the flight without waiting for just one more day for the RT-PCR test. The onus is on the service provider, which is an expert in that field.
I'd like to respond in 2 points, Your Honors. We accept that the defendant is the expert in this case, but their obligations can only extend so far. And so as we have demonstrated, they've done everything they reasonably could have given the circumstances, right? And second, while it's true that the claimant is the weaker party here, it doesn't take an expert to know that if you don't disclose a medical symptom you are experiencing, then there is a risk that you might get sick. That is just a very simple premise to get in grasp with. And this is why ultimately the defendant, the claimant, was not able to participate in the spaceflight activities. I hope I've answered your questions, Your Honors.
Yeah. Thank you.
Thank you.
Yeah, I think we'll have the senior counsel from the claimants to rebut this.
Yes, Your Honor.
And you will
Firstly, I
have
would
6
like
minutes.
Yes. Your Honor, may I confirm the 6 minutes, which includes the time for this junior counsel?
The junior counsel will have her own 6 minutes, right? So
6 minutes. Okay. Yeah.
yeah.
Thank you. I would like to address the defendant's submissions in 3 points. Firstly, I would like to reiterate from my submissions that the defendant has fallen below the standard by failing to comply with the necessary regulations by putting the claimant at risk. That is by not making sure that all the participants, including the claimant, are fit for the retreat. Moreover, the defendant's actions here may not be considered reasonable and being an exceptional situation, as they were aware of the COVID situation and it's not an unprecedented one, as it can be seen from the cursory medical tests which were conducted in this slide. Secondly, I would like to address the submission about the defendant's reasonable actions in this situation. So here, the claimant was identified COVID-19 positive 1 hour after the launch, where the best decisions the defendant could have taken was to wait until the tests were to return or to reschedule the flights as per the clause 1.2 of the contract. Instead, the defendant chose to launch the flight, risking the life of the participants, including the claimant, by relying on the nurse who is not qualified as per the said regulation. Thus, the council reiterates that the defendant has fallen below the industrial standard by considering their commercial interest over the participant's safety, and thus being negligent in their action, causing losses to the claimant. Lastly, all the submissions relating to the claimant's non-disclosure will be discussed by my co-counsel. Subsequently, the council argues that she is entitled to $15 million, which was deprived of her because of the defendant's negligence and non-performance of the contract. That's all, Your Honor.
Thank you. Senior counsel for defendant, is there a rebuttal on this? You don't have to, but if there is one, you can advance.
Yes, Your Honor. Your Honor, I'd like to clarify from the start that the reason I addressed the claimant's non-disclosure is because it pertains to her voluntary assumption of risk. And so with that, I'd like to respond in 3 points. The UAE spaceflight activities regulation doesn't set out that the operator's obligation is to make sure that everyone's fit for participation. It's only to take reasonable measures or to provide evidence that they are fit for that participation. And so the lateral flow tests are evidence of that. And second of all, this case does have to be treated as exceptional, and specifically with regards to COVID, because there were no clear guidelines at the time as to how this new variant should be tested and the effectiveness of both the PCR and the lateral flow tests on detecting it. And third, now that we know how long it took for the test results to come back, and the fact that the claimant was infected with COVID, it's easy to see it's easy to say that the defendant should have acted more reasonably. But we need to afford them the hindsight that they deserve, because at the time there was a lot of uncertainty, and we have demonstrated that in our pleading. Thank you, Your Honors.
Thank you. Junior counsel for the defendant, you will proceed with the counterclaim. You're on mute.
Yes. Your Honors and opposing counsel, good afternoon. I am Shireen Ahmed, the junior counsel for defendant, and I will lead on the counterclaim that the claimant, Ms. Artemis, is liable to the defendant, Solar Dream, for breach of contract. Your Honors, the crux of the matter lies in the contractual agreement between the parties. By signing the contract, the claimant committed to disclosing and informing about her medical condition. These were provisions she neglected on multiple occasions, and this breach of contract renders the defendant eligible to claim damages of $5 million. I will address 3 pivotal points. First, the claimant's failure to declare her medical condition and inform about changes to her condition constitutes a non-performance and thus a breach of contract. Second, this breach of contract entitles the respondent the right to claim for damages. And lastly, if the court finds that the claimant did not reach the agreement, the claimant failed in her duty to cooperate and the duty of best efforts as per the DIFC contract law. Let me develop these submissions briefly. The claimant signed the space flight agreement, which contains 3 clauses in particular that mandate the disclosure of the claimant's medical conditions. My first submission addresses that the claimant breached these contractual obligations. Your Honors, could you please turn to page 4 of the space flight agreement, or on PDF, that's page 14. Here, in Part 5 of the agreement, this discusses the clauses regarding the medical evaluation. Clause 5.2 requires the claimant to declare and represent that she is unaware of any medical conditions or symptoms that could affect her fitness to participate in the space flight. Additionally, as per Clause 5.2, she was supposed to provide accurate and complete information during the medical evaluation with the specialist doctor. 2 days after the claimant purchased the ticket for the spaceflight, she was provided the declaration form and a medical history log to fill out. She also met the specialist doctor who conducted a physical examination and several other tests to check her fitness levels. The claimant admits that she made no mention of her chronic headaches as she was afraid that she would not be allowed to participate in the retreat. This shows that she intentionally did not disclose this information as it would affect her fitness to participate. The following clause of 5.3 is of utmost importance. The claimant was required by this clause to promptly inform about any change in her medical condition between the initial evaluation and the scheduled launch date. A week before the flight, the claimant began to suffer from a severe headache while at the pre-departure accommodation. Despite it being unpleasant, she once again did not mention this to anyone, including the defendant. Furthermore, on the day of the spaceflight, her headache continued as a dull ache and she was feeling tired, but did not inform the defendant again, thus not obliging with clause 5.3. Lastly, as the claimant signed the agreement, she also agreed to bear the responsibility for reporting changes in her medical condition as per clause 5.5, which further states that the failure to report can impact their eligibility to participate in the spaceflight. The claimant may argue here that the defendant had deficient safety protocols. However, the defendant's medical evaluation included the review of the claimant's medical history and the physical examinations, both during which the claimant did not disclose her chronic headaches, and thus representing her medical conditions inaccurately and incompletely. Your Honors, the defendant has fulfilled their obligation by providing a medical declaration form, a medical history log, conducting the medical evaluations, and providing the pre-departure accommodation as per the safety protocols. The claimant's failure in obliging with clause 5.2, 5.3, and 5.5 of the agreement posed risks to the defendant's interest. Not only was the
Counsel,
defendant
while this is kind of making perfect sense from the contract point of view, uh, do you not think that defendant owed duty of care towards not just the claimant here, but also all other passengers, and therefore they should have waited for the RT-PCR results? So contractually, you are a big company, you've drafted, terms and conditions which probably were not even negotiable. But your duty of care towards not only the claimant but all other passengers of the flight was to required you to wait for the RT-PCR result. So can you argue breach of contract from claimant when you yourself have failed in duty of care?
Your Honor, the defendant had several examinations and evaluations conducted, and the claimant had the opportunity then to mention about her headaches, which would have allowed the defendant to take the necessary precautions, or to be like, if she had mentioned her headaches before, they would have known that there's a difference between her chronic headaches and the headaches that she was feeling in the pre-departure accommodation. About the PCR test, since the lateral flow came negative, the defendant's view from the nurse's perspective was a reasonable thing to do at that point. Had the claimant followed with the duty to mitigate the risk, the defendant also could have done so. And not only was the claimant's failure in obliging with the contract not only prevented the defendant from exercising their right to deny boarding to the passenger, all the passengers and the crew of Space Yoga Mat had caught COVID and had to return to the Earth earlier than scheduled. Because of this, the defendant also faced significant reputation loss and the cancellation of reservations for future space flights by passengers. Furthermore,
excuse me for interrupting the council. Do you not think then that by letting the passengers board in advance of the PCR test results, the company increased its damages? Because it's obvious that the company will have to pay compensations to the other passengers as well. Those damages could have been avoided. No?
Your Honor, as the time for the takeoff approached and that they wouldn't have been able to fly out, it was reasonable at that time for them to go ahead with just the lateral flow testing all negative. And it was due to the claimant's failure to disclose her medical condition that constituted the non-performance of the contract. This moves on to my next point about non-performance. As per Article 77 of DIFC contract law, non-performance is defined as the failure by a party to perform any one or more of its obligations under the contract. Non-performance is defined, contract, including defective or late performance. Here, the claimant had the obligations to declare her medical condition accurately and inform about changes to her medical condition, neither of which she performed. This is thus non-performance of the contract. In a precedent DIFC case, case number SCT 467 of 2022, in this case, the Small Claims Tribunal found the defendant to have failed to deliver the products, which the claimant had paid the deposit for. The DIFC court found the defendant's non-performance to have substantially deprived the claimant of what it was entitled to expect under the contract, and that the defendant's non-performance was intentional or reckless. Furthermore, the court found that this failure amounted to a fundamental non-performance and that the defendant shall refund the claimant and shall pay the court fees along with the further remedies. Similarly, in our case, the claimant failed to disclose and inform about changes to her medical condition. Article 86, Part 2 of the DIFC contract law states the requirements for determining whether a failure to perform an obligation amounts to a fundamental non-performance. The claimant's non-disclosure is a fundamental non-performance as it substantially deprived the defendant what it was entitled to expect under this contract, which is the disclosure and the report of change in the medical condition. Additionally, the obligation of informing about the medical condition is of essence under this contract for the safety and success of this mission. The non-performance was also intentional as the claimant was afraid she would be denied boarding. Thus, the claimant's failure to disclose her condition is a fundamental non-performance and a breach of this agreement. This brings me to my second argument that the defendant is entitled to claim for damages. The non-performance by the claimant gives the defendant the right to claim for damages as per Article 109 of the DIFC contract law. This article states that any non-performance gives the aggrieved party a right to damages, either exclusively or in conjunction with any other remedies, except in the case where the non-performance is excused under the law. Here, as there was no impediment beyond control for the claimant to not have informed about her tiredness and her severe headache, the non-performance cannot be excused. The DIFC contract, thus the defendant is entitled to claim for damages. Additionally, as this non-performance caused the defendant the harm of reputational loss and the loss of gain deprived by multiple passengers canceling their reservations, the defendant is entitled to full compensation as per DIFC contract law, Article 110. In a similar case of Matthias v. Maya of 2021, the DIFC court found that the defendant liable for the damages and compensation sought by the claimant for breach of contract. Parties had a tenancy contract which the defendant sought to terminate without notice. This is a breach of the contractual terms. The court refers to the DIFC contract law, Article 109 and 110, regarding the right to damages and as full compensation for non-performance. This case supports the argument that the defendant, Solar Dream, is entitled to damages in full, which is $5 million, because a claimant failed to fulfill its contractual obligations, which is non-performance. The DIFC contract law is based on the UNIDROIT principles of international commercial contracts. I will address its commentary from here on as a UNIDROIT commentary. As per the UNIDROIT commentary, to claim for damages, uh, proving that there was non-performance depends upon the content of the obligation and on whether the obligation is one of best efforts. This can also be seen in Article 59 of the DIFC contract law. Thus, I will address my final argument that the claimant failed in the duty of best efforts under the DIFC contract law. As per Article 59.2, there is a duty of best efforts to the extent that the party is bound to make the best effort in the performance as would be made by a reasonable person of the same kind in the same situation. The claimant's intentional non-disclosure of changes to her medical condition goes against the duty of best efforts. The DIFC contract law provides a criteria to determine the extent to which the obligation of the party involves the duty of best efforts for the performance of this activity. The claimant had a duty of best efforts, which she failed based on this criteria required by Article 16. This is because the obligation of disclosure and informing about change in her medical condition was clearly expressed in the agreement. Second, there was a high contractual price of $10 million US. And as per UNIDROIT commentary, an unusually high price indicates a duty to achieve specific result in situations where a duty of best efforts is assumed. In other words, when the price is high, such as $10 million, a duty of best efforts was expected, and so was a duty to achieve specific result.
Yeah, counsel, that principle also applies to defendant because it was not just this claimant, all other passengers had paid 10 million each. The best effort argument applies to Solar Dream in as much as it applies to the claimant.
Your Honor, the claimant had multiple opportunities to inform about her medical condition. Still, she chose not to, as she did not want the defendant to deny her from boarding. Had the claimant done so, the defendant could have taken the necessary measures, but they still did. The pre-departure accommodation was as per the safety protocol. Them bringing back all the passengers and the staff from the safe flight was also the best they could do in that situation because everyone had got COVID.
Right, counsel, my challenge with defendant's position in counterclaim is this. Now, as far as this particular claimant is concerned, probably those arguments hold water. However, the underlying premise the defendant is arguing is that claimant had certain contractual obligations to disclose. They did not do so. However, as a space flight operator and giving due regard to the regulations in the UAE, the requirements of FAA and the UK, the spaceflight operator had a broader duty to all the passengers to independently evaluate every passenger's disclosures or lack thereof. So, taking a particular passenger's disclosure on its face value is a disservice to all other passengers because anybody could easily say that they do not suffer from XYZ condition, but that eventually exposes the same condition to other passengers in a closed setup environment like a space flight, right? So that so the Solar Dream had a bigger and broader duty of care to all the passengers, and it doesn't stop with them writing down in the agreement that each passenger has a duty to disclose what they're suffering from.
Your Honor, beyond just the contract, the defendant had presented multiple opportunities for all the claimants to fulfill their duty of disclosing the medical condition. The claimant, Ms. Artemis, failed to do so. She failed to cooperate. She did not oblige with the duty to cooperate. And the defendant had the medical testing. They did the quarantine. They asked for that. And they have taken all the necessary precaution for the safety and safety of all the passengers. But because the claimant failed in her obligation, claimant failed to just disclose her medical condition, she brought this upon herself.
Okay, all right. I must remind you, your time is over for this project, so you may quickly conclude the submission
Esteemed
for the
judges,
counterclaim.
in conclusion, the claimant breached the contract by failing to disclose her medical condition and informing the defendant about changes to her medical condition. Had the claimant informed, the defendant could have taken the necessary precautions to safely execute the space flight and prevent the reputational loss from occurring. The claimant also failed in fulfilling the payment obligation of the remaining 2.5 million, and the claimant's non-performance and breach of contract entitles the defendant to claim full compensation for the damages of $5 million. Therefore, we request the court to find the claimant liable to Solargym for the breach of contract and find the defendant entitled to receive the requested damages. Thank you.
Thank you. Junior counsel for the claimant.
Yes, thank you, Your Honors. May it please the court, as has already been indicated by the senior claimant, Ms. Ryan Hamid, my name is Ms. Sarah Jumshed, and I appear in this case as the junior counsel for the claimant, Ms. Artemis Astrathea. Your Honors, I shall be dealing with the second issue in the proceedings, which is that the claimant, Ms. Artemis Astrathea, is not liable to the defendant, Solargym Incorporation, neither for breach of contract for failing to declare her medical condition, nor for the commercial reputational harm suffered by Solargym. Your Honors, I have two submissions to make. Firstly, the claimant has not breached the agreement by failing to declare a medical condition, as the non-disclosure does not amount to a fundamental non-performance strictly required under the agreement. Secondly, the claimant is not liable for commercial reputational harm suffered by Solargym, as she reserved the right to document and publish her experience for the sake of public interest, because it was not her because it was not her statement that had caused the reputational damage. Your Honors, if I may begin with my first submission. I submit that the claimant has not breached the agreement by failing to declare a medical condition, as the non-disclosure does not amount to a fundamental non-performance strictly required under the agreement. According to Article 86 of the DIFC contract law, found in page 11 of the bundle, fundamental non-performance is only when there is an obligation to perform under the contract. Such a failure to perform a contractual obligation is a fundamental non-performance in four types of circumstances, which are when it substantially deprives the aggrieved party of what it was entitled to expect under the contract, if strict compliance with performing the obligation was of essence under the contract, if non-performance was intentional or reckless, or if the non-performance gave the aggrieved party reason to believe that it cannot rely on the other party's future performance. If I may direct your honors to the case of Yusuf Issa Ward and Demek Park Towers Company Limited from 2014 of the DIFC Court of First Instance's first judgment of 2015, found in page 30 of the bundle. Would your honors benefit from the facts of the case?
So you may address the principle. We can
Thank you, Your
skip the
Honors.
facts. You can elucidate on the principle, please.
Thank you, Your Honors. In his judgment, Judge Al Nasser confirms that Article 86 of the DIFC contract law may also be used to assess whether there has been a material breach or fundamental non-performance of the contract. When it comes to the medical evaluation, Clause 5.2 of the agreement in the present case stipulates that the passenger is required, to the best of their knowledge and belief, to declare during the medical evaluation any medical conditions that may affect their fitness to participate in the spaceflight. Clause 5.3 further reiterates the point that the passenger need only declare a medical condition or symptom that they believe, to the best of their knowledge and belief, would affect their fitness to participate in the spaceflight, but regarding the disclosure of such changes that occur between the time of the initial medical evaluation and the scheduled launch date. The claimant, who suffers from chronic headaches, does not mention this condition during the medical evaluation, as they have been a recurring phenomenon for the past 5 years. Since this was not uncommon for her, she did not disclose the information during the medical evaluation, as she had genuinely believed that the condition would not affect her ability to participate in the retreat and its activities, as she had been successfully able to travel to many exotic locations and perform yoga and meditation without it affecting her fitness to perform any of those activities. Since the claimant could safely take potentially long flights to such exotic places, she had reason to hold the belief, to the best of her knowledge, that her headaches would not affect her fitness to participate in the spaceflight, and thus there was no obligation on her to disclose them. Furthermore, applying Article 86, her non-disclosure does not deprive the defendant of anything they were entitled to expect under the contract, as the headaches were not debilitating to her fitness, and so was not required of her to disclose. Moreover, the claimant cannot have been required to disclose her headaches, as it was not of the essence to the agreement, as she could have carried out in her participation in the spaceflight and its activities despite her headaches, as it is a normal everyday occurrence for her that is more of a minor inconvenience than a debilitatingly weakening condition that would make her unfit for participation. Additionally, since there was no duty to disclose her headaches under the agreement, she cannot have been reckless or intentional, as she genuinely believed it would not affect her fitness to participate, and it cannot be said that led the defendant to reasonably believe that they cannot rely on the claimant's future performance, as she acted honestly and reasonably to the best of her knowledge and in good faith. To conclude my first submission, Your Honors, the claimant has not breached the contract by not disclosing her headaches, as she acted within the terms of the agreement to the best of her knowledge, as was required of her contractually.
Counsel, the reason why claimant, and I believe it is stemming from the facts of the case here, is the claimant's reason for not disclosing the facts was her apprehension that such disclosure will prevent her taking the flight for the very obvious reasons, right? That completely devoids her of any good faith.
Your Honor, I would like to reiterate the point I mentioned in my submission that she also had the reason to believe that because they have been a recurring phenomenon for her, and she's been able to partake in many activities in like meditation and travel without her headaches affecting her in any way. She had the reason to believe that it would not affect her fitness to participate, which was the main term of the contract in which she had acted within.
The headaches she experienced in the last week was not the normal headache she was experiencing. It had aggravated
Well, Your Honor,
significantly as per the facts.
well, according to the facts, it was a dull ache, which would mean that the headache was not as painful as it would have been normally. So she had every reason to deduce that her
I
condition.
Yeah,
Yes,
please
Your
carry
Honor.
on.
Thank you, Your Honors.
sorry, before I
If
forget
I
to
may
ask
move.
one other
Yes.
question here. You said that the pain was normal, or the way your client felt it was something of a normality. But according to paragraph 4.3 of the contract, the passenger is aware of the potentially adverse impact of microgravity on the human body. So was it reasonable for her to anticipate that the pain would be normal if the conditions surrounding her would be not normal, that that there would be adverse effects, which rather than that would rather increase the pain?
Your Honor, these adverse effects you refer to mostly pertain to cardiovascular and other neurological conditions occurring within the body, rather than headaches that are a result of an uncommon medical ailment. So she had the reason to believe that it would not affect her fitness, or that she needed to disclose these headaches for those reasons.
Right, counsel, going back to my previous point, there is a distinction in the degree of headaches she was experiencing. So the dull headaches were prevalent. However, if you look at para 9, it says during the second week, she began to suffer from a severe headache. And then para 10, then the distinction. A day before, on the day of space flight, her headache continued, although now it was a more of a dull ache. So on the day of space flight, probably that had subsided, but a week before, the entire week, it was a severe headache, which is not If the argument is that it was always there, it was not impacting her overall fitness to carry on with her day-to-day life, then that's clearly not the case factually here.
Well, Your Honors, again, I would like to reiterate the same arguments that I have already mentioned, that despite the severity of her headaches, even if it was very severe, she could have easily participated in the spaceflight and its activities, as she has been able to do so for the past 5 years. And when it comes to the travel she's done or the yoga she's participated in.
But has she traveled within those 5 years? Has she traveled to space within those 5 years?
Well,
Was it
no,
or was it something of a new type of experience?
Well, yes, Your Honor. This was a new experience for her, but it must be understood that the claimant here is not an expert when it comes to space or space flight, and so she would have had the reason to believe that her headaches would not make her unfit to participate, as it was not uncommon for her.
All right, Sharon, you can move on to the next
Thank you, Your
argument.
Honors. Moving on to my second submission, I submit that Ms. Astrathea is not liable for the commercial reputational harm suffered by Solar Dream, as she reserved the right to document and publish her experience for the sake of public interest, and because it was not her statement that had caused the reputational damage. I would like to direct Your Honor's attention to the case of Arkham Capital Limited and Dubai Financial Services Authority of 2012 from the DIFC Court of First Instance's Sixth Judgment of 2013, found in pages 27 and 28 of the bundle. Justice Chadwick stated in that case that for a business to prove it suffered commercial reputational damage due to a statement made by another party to a contract, there must be a contractual reliance on that party not to disclose the information that can cause a reputational harm. Additionally, the harm must be properly weighed against what would be caused to a company's legitimate business interests if the statements made were heard in public against the public interest in publicity. I would like to direct Your Honor's attention to the case of Amira Seafoods and International DMCC and IDBI Bank Limited and another of 2018 from the DIFC Court of First Instance's 27th Judgment of 2019, found in page 32 of the bundle. In this case, Justice Giles confirms that to claim damages for commercial reputational damage, the reputational harm must have had a negative effect on the company's business and trading, caused by the other party's statement. In the case at hand, the defendant has not relied on the claimant to keep confidential her experience with the spaceflight and the retreat, as there is no clause in the agreement that states she must not film, document, or publish her experience in the spaceflight. In fact, it was reasonably foreseeable that she would publish the activities, as she's a well-known YouTuber who has announced her participation in the experience. So there cannot have been any obligation for the claimant to withhold such information. Excuse me, Your Honors. Moreover, Ms. Astrathea documenting her experience. I do apologize, Your Honors. Moreover, in fact, it was reasonably foreseeable that she would publish the activities, as she is a well-known YouTuber, and also Ms. Astrathea documenting her experience and publishing the information to the public is within the public interest, as people have the right to know about a company's business practices and adherence to relevant protocols. Sorry. In this case, the claimant's lack of adherence to the recommended practices for human spaceflight under Clause 7.2a of the agreement. The clause states that the spaceflight operator or the defendant must undertake reasonable efforts to ensure that its safety protocols are in compliance with the latest version of the United States Federal Aviation Administration's recommended practices for human spaceflight occupant safety, found in page 33 of the bundle. According to the latest version of the document, which was published in please excuse me, which was published in September 2023, Section 4.4.4 on health stabilization and medical planning states that the operator must identify specific types of medical conditions and medical criteria for ending flight early. They must also have implemented quarantine or social isolation procedures to prevent infectious diseases from manifesting during spaceflight, so they may be prepared to react in a prompt manner to address medical situations. Solar Dream failed to adhere to these measures despite their spaceflight retreat taking place in January 2024, months after the document had been published. They failed to test for the Vulcan variant well in advance so that they could have implemented necessary quarantine measures, despite being aware of its virulence months prior.
Council,
Moreover,
just a
the
reminder, you're about to be done with your time, so you may want to conclude.
Okay, thank you, Your Honor. I would like to contend that there is nothing that suggests that it was the claimant's statement that had caused their reputational loss. So I conclude that conclude my third submission that Ms. Astrathea's statements are not the cause of Solar Dream's commercial reputational harm, and thus she cannot be liable to pay damages under breach of contract. For these reasons and the ones stated by my learned senior, I urge the court to find in favor of the claimant, Ms. Artemis Astrathea. If Your Honors has no further questions, that concludes my submissions for the second issue in the proceedings.
Thank you. No questions from my side. Defendant, do you can proceed with the rebuttal?
Thank you. Yes. The claimant breached the contract, which required her to inform about any change to her condition between her initial evaluation and the day of the spaceflight. She had a severe headache during the pre-departure accommodation and had tiredness on the day of the spaceflight. Even if the claimant believed that her chronic headaches did not affect her fitness to participate, she chose not to as she did not want the defendant to deny her boarding. We do not dispute that she had the right to publish this experience online, but at the same time, the defendant had no legal or contractual obligation to ensure that she could film her video and post it. And although she interpreted the disclosure agreement as subjective and that the defendant was the expert, we cannot enforce an unreasonably low standard on her, as it takes a lot of competence to have 27 million subscribers on YouTube. She should have minimized the risk and been more cautious to disclose her headaches. The claimant's failure to disclose her chronic headaches, the dull ache, and the tiredness was a breach of her obligations under the space flight agreement. And the defendant is entitled to damages of $5 million for this breach and the reputational loss. Thank you.
You, Clement, do you have a rebuttal?
Yes, thank you, Your Honors. Regarding the junior defendant's points that she had a severe headache before the launch of the spaceflight, I contend that she did not, according to the facts of the case. She had a dull ache, which which meant that she did not suffer from it as to the same severity as she normally would. In fact, it was lesser than she normally would. And so there was, again, no obligation on her to disclose those headaches to the defendant. And moreover, there was no risk to minimize either. There was no, her headaches did not pose a risk to the defendant or the crew or the participants of the spaceflight, and therefore there was no risk to minimize, as her headaches only affected her and would not put anybody else at a risk. And for those reasons, I conclude my rebuttals.
Thank you. So I believe that is the conclusion of the arguments from both claimant and the defendant. I believe the judges will break out in a different room, but I do want to consult both my fellow judges. Do you guys want to share the feedback now, or do we go back, discuss, and come and then provide feedback? Because
I
we'll
think
be
we should.
discussing scoreboards. Yeah.
Sorry.
We can wait for you, Your Honors.
Yeah, I think we should go and consult first and then come back.
Sure. Okay.
From my part, but Anton.
Yeah, same.
Yep.
All right. So claimant and means counsels, please wait for us. We'll come back in this room. You can mute and turn your camera off. We'll buzz you here when we are back.
Hello.
Yeah.
So you must have received judges breakout room link as well, right? So if
Do
you
you
want to
mind,
take
Deepesh? Can you just share it here in the chat so it's
Okay,
easy so
I'll
we
do
can
that.
just click it.
Sure.
Okay.
You both did so well. You guys are so
Congratulations,
good.
guys.
Oh, did they leave also? Oh no.
No, thank you. You guys did well too.
Yeah, you guys were
Is this your
fantastic.
first year
Yes, you
doing
guys did really well.
this moot?
Yes, this is the first
Yep.
time. And you
Same
guys?
for us. Same for us. Okay. Oh, you guys are in Dubai?
Yes.
Yeah.
Yes, we are.
We're in Qatar.
Oh,
Anything else?
Yeah. Wait, is my voice echoing?
Oh, sorry.
Sarah, on Tuesday, I made the same argument about how the disclosure obligation should be read in a subjective way, and that
Yeah,
she
I
didn't
know.
think.
I know. I was too late to change it. I already had my argument, so I just used the same thing again. Yeah. I know
It
because you
was
were
good,
saying it and
actually.
oh, thank you. But I attended your your because it was against our defendants as well. So I attended it and you had
Okay.
pretty much exactly the same arguments as I did.
So you
It was a little
stole
creepy.
my argument.
No, you stole
Okay,
mine, I
see.
think. It
No,
was a
no,
little
no, no.
creepy.
I said it first.
You're their role model. Anyways, okay. Was it too quick, like when they told you that you've made it through? Or were you expecting it?
no, we were not
weren't
expecting it.
at all.
Okay, same. I was comfortable in my pajamas. Oh, this being recorded.
Yes, it is.
That's all right.
I'm gonna stop talking. Did they ask us that they could be recording and to publish this on YouTube?
They did not.
Okay, that's what I thought.
They didn't. Yeah, they didn't.
All right, we won't keep you if you have to go. We'll see you back and when the judges come.
Yes. All right. Thanks for waiting, everyone. And first of all, great work by both sides. Reflects a lot of hard work. Methodology. Very succinct use of facts, legal principles, shows the depth. I guess it's a really great job. uh, Again, the feedback reflects on this particular case. So again, if there is any negative feedback, it's specific to this, so that doesn't mean that's how your professional life will be. So but yes, take it as a learning opportunity. From my side, I think both sides have done great. I believe maybe yes, we felt that one side was stronger in the persuasiveness, use of authorities, versus the other, but that's probably because of the facts of the case are as such. Um, but overall, from my side, the key thing that stood out was to to be able to that grasp all the legal principles, whether it's a contractual DIFC regulations or the principles of tort. I was very happy to see that you guys were referring to the case laws, the English case laws. Saw very good court craft and mannerism as well, except one instance where I did notice that two of the councils were chatting with Moot on, but that was probably distracting everybody else. So that should not, probably try and avoid it. In regular court, probably that will not pass. That of course doesn't reflect on anything else, but that's something I definitely want to note. So that's it from my side. Yeah.
Yeah, from me, maybe a couple of words from me. I'm very impressed. Everyone was well prepared, great presentations. Of course, there's always room for improvement. And again, just thinking aloud, in general terms, what I think could be addressed a little better. Let's say that on the defendant's side, the argument of the balance of power, um, professional service provider versus weaker party, and on the claimant side, the bad faith argument, lack of disclosure. But again, it's just to say something. It doesn't mean that you didn't handle it well. Absolutely stunning. It's just to to offer some further steps for improvement. That's all. That's all for me.
Oh, I get the last word, so that's good. I think your fictional clients, and I'm talking to everybody now, I think your fictional clients, your respective fictional clients, would have been very proud of all of your submissions. You delivered them well. As the only Brit in the room coming from the UK and sitting in the UK, your use of UK cases were extremely well felt by me. But I thought you all did a stand-up job. Congratulations. You should all be proud of yourselves. You hit all your points that you'd prepared for extremely well. It showed in your delivery. But anyway, that's it from me.
Okay.
Thank you, Amir and Antov, and thanks both counsels on the both sides. I believe this is all. Webnyay team, and we will close this meeting now. And I will.
Best of luck,
Thank
everybody.
you all very much.
Bye-bye.
Have a good day.
Thank you very much.
Thank
Have a
you.
nice day.